All right, let's talk about divorce. But not just any divorce. We're diving into a legal system where splitting up isn't enough. Now, in this world, you have to prove that your partner is the one to blame.
I mean, it seems simple, right? If a marriage has just completely fallen apart, if the love is gone and the relationship is just over, shouldn't that be enough to, call it a day?
Well, in a lot of places around the world, that is the end of the story. But in India, the law often says, hold on a second, it's not enough to show that the marriage is broken. You actually have to point a finger and prove who broke it.
And this gets us right to the heart of the legal blame game of divorce. It's a system with a really long and pretty complicated history. So what exactly are we talking about here? We're talking about something called fault-based divorce. And it's basically a legal process where you can't just get a divorce. You have to win it. One person has to prove in court that their spouse is guilty of a specific, legally defined matrimonial offense. It's not about the marriage being over. It's about proving why it's over and that it's all their fault. And you might be wondering, where did this whole idea come from? Well, this legal framework was pretty much imported from England back in the colonial era. You see, the English passed their Matrimonial Causes Act in 1857, and just 12 years later, bam, India's Divorce Act was passed, based right on that model. This whole system of finding fault was then locked in for most of the population with the Hindu Marriage Act in 1955.
So what kind of offenses are we talking about? What do you actually have to prove? Let's kick things off with the one everyone knows: adultery.
The legal definition here is very specific. It's voluntary sexual intercourse between a married person and a third party. And that word voluntary is key. If someone was forced, it wouldn't meet this legal standard at all.
Now here's where it gets tricky in court. Legally, just one single act is enough to grant a divorce. But think about it. How often is there going to be direct proof, an eyewitness? Almost never, right? So the courts have to rely on circumstantial evidence. They look for things that show a high degree of probability, which is, interestingly, a lower bar than the beyond a reasonable doubt standard you'd see in a criminal case.
Okay, next up is another ground for fault: desertion. And believe me, it's a bit more complex than it sounds.
This is not as simple as just one person packing a bag and storming out. For it to count as legal desertion, you've got to have two things happen at the same time. First, the obvious one, the physical separation. One spouse actually leaves the home. But second, and this is crucial, you need the intention to desert. They have to leave with the mindset that this is it, we're done, I am never coming back.
And you can't just file the next day. There's a waiting period. The state of desertion, with both the separation and the intent, has to go on for at least 2 full years without any interruption before you can even file for divorce on these grounds.
But here's where the law gets really interesting and, a bit more nuanced. What if you're the one who leaves, but it's only because your partner's behavior made it absolutely impossible for you to stay? That's a concept called constructive desertion. The law actually recognizes that the person who physically walks out isn't always the one who truly abandoned the marriage.
This classic legal observation just nails it. It says that the spouse who stays behind might actually be the one really responsible for the breakdown if their conduct drove the other person away. So in the eyes of the law, they're the one who did the deserting. And that leads us to our third ground for fault, and it's probably the toughest one to pin down: cruelty. Now, it's super important to understand that legal cruelty is not about the everyday arguments or disagreements in a marriage. The courts have a phrase for that: the normal wear and tear. To be grounds for divorce, the behavior has to be something much, much more severe.
So, cruelty is usually split into 2 types. Physical cruelty is pretty straightforward. We're talking about violence, assault, that kind of thing. But mental cruelty, well, that's a much bigger umbrella. It's basically any conduct that causes such intense mental pain and suffering that it makes it completely unbearable for the other person to stay in the marriage.
And when you look at what the courts have actually called mental cruelty, it's pretty eye-opening. It's often a pattern of behavior, things like constantly demanding dowry, falsely accusing your spouse of cheating, deliberately refusing to have kids, filing fake criminal charges, or even threatening suicide to manipulate them. And here's the kicker. The person doing these things doesn't even have to intend to be cruel. The law is way more focused on the impact of the actions, not the motive behind them. If someone's behavior, whether it's from selfishness or just pure malice, causes serious harm to their partner's mental health, that can be enough. So, after looking at all this, the blame, the need for proof, the often painful and really long legal fights, you gotta start wondering, is this whole system just broken? And this gets to the very heart of the modern debate. What happens when there isn't a single provable fault? There's no adultery, no one's legally deserted anyone, there's no cruelty. What if the marriage has just died?
And you know who's been asking this question? The Supreme Court of India. In this really famous case, Naveen Kohli versus Neelu Kohli, the court basically said, look, once the marriage is broken down beyond repair, it would be unrealistic for the law not to take notice. They argued that forcing a couple to stay in a marriage that's become a legal fiction, while the court said it shows scant regard for feelings and emotions. That is a powerful statement.
This argument is for a whole different approach, a no-fault ground for divorce. It's called the irretrievable breakdown of marriage. And it's a legal concept that just acknowledges reality, that sometimes a marriage is simply over. The bond is gone, and forcing two people to stay legally tied together just doesn't help anyone.
And that really leaves us with the big question, doesn't it? Should the law keep digging into the why? Should it demand proof and point fingers? Or should it evolve to just accept the reality that a marriage has failed and allow people to move on with their lives? The debate is very much alive, and its outcome will literally change the future of family law for millions.